All right. Well, thank you very much for the privilege of speaking to you all tonight. Thank you very much to Ben for your great work up here. You're always a hard act to follow, and never more so than tonight. I really enjoyed your talk. Thanks for coming, and thanks for being here with us. And thank you all for still being here. After dinner would be a great excuse to sneak out the door, but thankfully, you all have stayed with us to hear about the very highly engaging topic of business law. Okay, nobody's still sneaking out, so we're good. Of course, not everybody will start or own a business, and that's fine. So why do we need to think about business law? What is the relevance for our everyday lives? Well, some people do like to start businesses, especially things like little side hustles that can make some little extra money on the side. You might be interested in working with your church to start up nonprofit organizations to do various different things. If you already do own a business and are looking to expand it, there are considerations that you need to think about, particularly in the realms of business organization, contracts, and various other topics related to those. As Christians, especially, we need to know the laws surrounding economic activity in business for two reasons. Number one, we're commanded in Scripture to obey every ordinance of man for the Lord's sake. And as we engage in our economic lives, it's important to know and understand the rules that have been laid down to govern business activities so that we can follow them better. Number two, understanding and making wise use of the laws governing business activities is an essential component of wise stewardship of the resources that God has given us. We're commanded not to be wasteful. We're commanded to, excuse me, use our resources wisely as we take dominion over the earth in the name of Jesus Christ. So what I'm going to do in this section is I'm going to start with business organization and structure. And then we're going to get a general view of the pros and cons of several different types of business entities, the tax consequences, management structures. We're going to go through liability protections and the various implications and different things different entities are good for and bad for. Once we're through with that, we'll very quickly cover, fairly cursorily, a number of different areas where you might need the services of an attorney, including tax mitigation, liability protection, contracts, and intellectual property. So let's jump right into formation, business entity formation and definition. So the first type of business entity that I'm going to be covering tonight is the simplest entity. In fact, it's actually not an entity. It's the sole proprietorship. It's defined as one person doing business for profit. Simple as that. You don't have to file any paperwork with the state. In fact, if you did not file any paperwork with the state when you began your business and you're the only one conducting your business, you are a de facto sole proprietorship. There's no differentiation between any of your business property and your personal property. It's all owned by you. You are the business. So that makes it very simple to run. Your decisions are the business's decisions. You've got no formalities to worry about, no regulations to consider beyond what normally regulates whatever business you're doing. And the tax consequences are relatively minimal. You just enter everything on the good old Form 1040 that we all know and hate, fill out the Schedule C and the Schedule SE, and you're pretty well done. So what's not to love? Well, there are a couple things. First, a sole proprietorship, the same tax benefit that I just mentioned, if you grow your business to have a revenue stream that's large enough to put you in a higher tax bracket, corporate taxation can actually help you. It can actually save you money because the higher tax brackets are way higher than the corporate tax rate. And we'll get into that a little bit later. But it can be a liability if your business grows large enough. The second con of a sole proprietorship is related to the fact that all your property is owned by you and there's no separate entity involved. And that con is liability. You have no liability protection with sole proprietorship. And what I mean by liability protection is with certain other various types of business entities, like we'll discuss later, LLCs and corporations particularly, your business assets and your personal assets are distinct. So for instance, say I'm a sole proprietor of a business and I'm driving in my personal vehicle to a football game at, let's just say Alabama. Uh, and on the way, I pull out in front of somebody, cause a car wreck, right? Now, if my business was organized as an LLC, the people that I've injured could sue me for their damages. And they could go after my personal damages because the damage was caused by me in my personal capacity. They could go after my personal assets. They couldn't go after my business assets because my business didn't cause the damage, right? With a sole proprietorship, they can go after everything. Everything is always all on the line. This same principle applies to things like debts. If you're a sole proprietor, you get a business loan, you are personally liable for that business loan. So if your business fails, it's not just the business that may have to risk bankruptcy, it's you. So just keep in mind, if you're looking to start a business, these various risks that are involved with not having a legal entity other than just yourself. So sole proprietorships are simple, they're easy to manage, they're flexible, but they're an entity that I typically counsel clients to avoid, just because I don't think the juice is worth the squeeze on this one. The lack of liability protections, the lack of asset distinction, it's just too much risk for the added benefit of flexibility and ease of management, especially, as we'll see later, when there's business entities like LLCs that offer many of the same benefits without the drawbacks. So let's get further down into the next form of business entity that we're talking about. And it's actually the first entity that we'll be speaking of, and that is a partnership. What do you get when you have two people doing business without filing paperwork with the state, and they're doing business together? They own the business together, they're running the business together. It's called a partnership. Partnerships are another de facto business form. If you are two or more people doing business together, you're a de facto partnership. You can file certain things with the state. You can have a partnership agreement executed between partners, which is essentially a contract that is enforceable, that allows you to somewhat regulate the relationship between the partners, almost like a more corporate entity. But the partnership has a lot of the same drawbacks as a sole proprietorship does, namely, no liability or asset protection. Everything is all on the line for the partners. They're individually liable for the partnership's debts. They're individually liable for any of the other liabilities the partnership may incur. And as an added bonus, or, well, not so much of a bonus if you think about it, especially if there's no partnership agreement that exists, one of the partners can bind the partnership, including the other partners, personally and professionally, to agreements and obligations, even without the consent of the other partners. So that's just one other risk of doing business with other people without filing paperwork. Just something to be mindful of. I mean, if you want to do business in a partnership, make sure to go into business with people you really trust. Partnerships also, they're taxed very similarly to sole proprietorships. The partners are personally tax liable for all of both what they get paid and the extra profits. So we got a little illustration here. Peter, James, and John, right? Low effort name. They're business partners now. Last year, let's say their partnership took in revenue totaling $200,000, and that's after allowable non-salary deductions. Peter gets paid a salary for his work. It's $50,000. James is a little bit more productive. He gets $60,000. John, he serves as the partnership's bookkeeper in addition to his other duties, so he gets $80,000. The salaries all total $140,000. Yeah. Am I right? Okay. Yeah. Anyway, that leaves $60,000 in leftover profits. And I know this because, full disclosure, I did these calculations before I left home. So Peter, James, and John will each be taxed on their own salary plus their 1/3 share of the leftover $60,000 profits. So what they will each claim on their individual tax returns. Peter, with his salary of $50,000 and his 1/3 share of 20, will claim $70,000. James will claim $80,000. John will claim $100,000. So they're individually taxed. This is called pass-through taxation. So the tax code passes through the entity and reaches the individuals that compose the entity. That's why it's called pass-through taxation. It's a way of individually taxing an entity's profits. And it can be a significant advantage for Peter and James. Their salaries, including their extra profits, don't put them in a super high tax bracket. So if they had to pay corporate taxes on top of what they made, they'd lose money. For John, it could be a little different. $100,000 puts you into a higher tax bracket, which is actually higher than the corporate tax rate, but we'll cover that a little later. So there are pros and cons to doing business this way. However, like I said about sole proprietorships, there are other entities that are better, like the one we're going to think of now, the LLC. This is the first real corporate entity we've considered here. It's formed by a formal process by filing the correct paperwork with the state's designated authority. Here in Alabama, it's the Secretary of State's office. So you generally either have an operating agreement or you're governed by the statutory code known as the Alabama Limited Liability Company Act. And let's get this little thing out of the way. You often hear people talk about limited liability corporations. Those don't exist. It's a limited liability company. A corporation is a very different animal. And that we're going to cover that next, but there's a lot of differences between the two entities. So there's no such thing as a limited liability corporation. It's a limited liability company. So honestly, LLCs are kind of the new king of the hill when it comes to business entities. You see them popping up all over the place. And that's because they offer excellent flexibility of management style, full liability protection. You have an option of either pass-through taxation like a partnership or corporate taxation like a corporation. So you get to choose how you're taxed. And you also can have the option of creating your own operating agreement. And the beauty of this is that where the Alabama Limited Liability Company Act is silent, or where your operating agreement provides a provision different from the provisions of the Act, your operating agreement controls. So you essentially get to write your own law for your own business. And this can be very useful, especially if we're seeking to operate Christian businesses governed on Christian principles. For example, I've formed limited liability companies for Christian brothers with dispute resolution plans in them that mandate certain things to be followed, like the biblical dispute resolution procedure laid out in Matthew 18, which we'll also discuss later on tonight. But you can do a lot of these different things with LLCs that you can't do with things like partnerships, sole proprietorships. I mean, you can hold yourself to those things, but with an LLC, you have the operating agreement that can serve as a binding contract to bind all the members to those things as part of the LLC's foundational documents. So the single biggest advantage of an LLC is right there in the name, limited liability. You have full and complete liability protection, very similar to that offered by a corporation. An LLC's members are not personally liable for business liabilities or vice versa. So again, if I got into a car wreck on my way to the Alabama football game and they sued me personally, they can't take my business. They can't take anything owned by my business. They can't take any real estate that my business owns. They can't take any vehicles my business owns. They can't take any of my equipment. They're limited to my assets alone. And vice versa. If my business injured somebody, they can't go after my house. They can't go after my personal car, right? So they can go after something either way, but either way, you're not left with nothing. And this is part of the ethical conundrum that some people have with limited liability situations like this. The goal isn't to injure somebody and get out of paying. If that's your goal, God help you. The goal is to use your business resources and your personal resources wisely and protect them as much as you can while still doing justice. So if you cause damage to somebody and they really need the help, I mean, you should go above and beyond whatever a court would give them, right? And again, if we're talking about disputes between Christians, we'll cover alternative dispute resolution later tonight. But limited liability companies allow you to use your judgment informed by the Holy Spirit and by good counsel to do what you know is right, regardless of or without necessarily having to be forced to do what's right or to be forced to do more than is right in some cases. So I approach it as a wisdom issue where you are using the laws that have been set before you that you're told that you must obey. You're using these laws to protect not only your own property, because we're not thinking in terms of our own individual selves, are we? We're thinking generationally here. When we're protecting our assets, we're not protecting our assets for our own enjoyment, are we? We're protecting our assets for our children and our children's children. So part of this is going into that. And again, we'll discuss this more in detail next week. But an LLC, unlike the other entities we've discussed before, is capable of owning things that require a certificate of title, like real estate. A partnership technically can own real estate, but it's titled in the name of the partners, personally. An LLC can own real estate in its own right. So that's a big difference. There's also a lot of advantages, a lot of other advantages dealing with, going into how flexible they are to run and how you can add new members or dissociate members more easily than you might be able to from some of the other types of things. But there are some drawbacks. For one thing, LLCs require more formality to operate. And this is because the liability protections of an LLC can be lost if you're not careful to keep your business finances and your personal finances separate. So the LLC needs to have its own bank accounts, and all business assets need to be titled in its name. Excuse me. You then pay yourself a salary from the LLC's bank account, and you can make capital distributions to yourself from the leftover profits from time to time, as long as you do it according to the procedures in the operating agreement. But what you can't do is just take LLC funds for personal purposes all the time. Or if your business is doing poorly, right, just take personal funds from your bank account and just throw them in the LLC whenever you need. There has to be some procedure there to show the government that you're not just using the liability only, or the limited liability company only as a liability shield and not as a genuine legal entity. If it's a real legal entity, you need to treat it as such. So if you're not treating it as such, if you get into a dispute, the court might disregard your LLC and hold you personally liable for everything anyway. In lawyer speak, this is called piercing the corporate veil. I don't know if any of you have heard that before. I know you have been, but you need to be a little more mindful when you're doing business with an LLC for this reason. So those added for the formalities might seem like a lot, but the added liability and asset protections, combined with the tax and administrative flexibility, they make LLCs a great choice for business formation. They're my default business entity that I usually recommend when people come in wanting to start a business. This leaves corporations as the final business entity we'll consider tonight. And a corporation, like an LLC, is a separate entity formed by filing paperwork in the state in which the corporation is based. They're similar to LLCs in certain ways, but they're very different. They require more formalities to run. They also confer distinct advantages, especially for large or rapidly expanding businesses that are looking to get a lot of outside financing or investment, or for nonprofits. Of course, corporations are what we all think of when we think big business, right? They all have bylaws, corporate boards of directors, CEOs, half the time small armies of executive vice presidents of God only knows what, and of course, shareholders, right? They're the hardest type of entity to manage because you can't have a single member corporation. You can have an LLC that only has one member, and that one member makes all the decisions, runs the entire show, right? No extra formalities other than that. With a corporation, you have to have a board of directors. You have to have more than one director. So you have to make decisions in a more cooperative fashion, and they need to be formally made decisions too. You can't just, have corporate boards of directors run into each other in the street and make a snap business decision. You need to have an annual meeting. This meeting needs to be run according to certain principles. It's a lot to do. So why do people form corporations? Well, one of the biggest reasons is that it's the entity that makes it easiest to get outside financing and investment. And that's because, unlike an LLC, which has membership interests, where it's more like owning a house together with a bunch of people, right? Corporations are broken down into these little discrete pieces called shares. And of course, these are very easy to buy and sell, as we all know, from hearing about the stock market, which is the way a lot of large corporations get the bulk of their investment. You can also leverage stock for business loans much easier than you can an LLC membership interest, just because it's a lot easier because you know what you have, and it's a lot easier to value. It's a lot easier to transfer. So it makes it a lot easier to get outside funds. So if you're trying to rapidly grow a business, a corporation might be better for you than an LLC would, just because of that. There's other considerations as well, especially for nonprofits. The 501c3 designation, for example, is only available to corporations. You can't get it for an LLC. So if you're looking to form a nonprofit that's tax exempt under subsection 501c3, you need to have a corporation set up. So the biggest issue, other than the formalities of running a corporation and shareholders' rights and boards of directors and management teams, et cetera, they could get very, very complicated. It's a lot. But corporations are subject to what we call double taxation, and that is the corporation is taxed on its revenue, its profits, and then whatever of those profits that are paid to the shareholders, the directors, the managers, et cetera, they're taxed individually on that money as well. And that sounds like, well, you're paying taxes twice on the same money. Yes, you are. That's why it's called double taxation. But that's not necessarily a bad thing. For large revenue streams, it's actually a good thing. And here's why. You said lawyers didn't like math, Ben. Watch me. The current corporate tax rate in the United States is 21% of all profits after allowable deductions. Okay, nobody's snoring yet? Okay, good. Right now, personal income tax rates on adjusted gross incomes for a single taxpayer higher than $100,526 for a single taxpayer or $201,000 for married filing jointly are 24%. That's higher than the corporate tax rate already. So the highest income tax bracket for all income higher than $609,000 for a single taxpayer or $731,000 for married filing jointly taxpayers is 37% of adjusted gross income. That doesn't even count property and sales tax. That's just income tax. So there's a lot of complexity in how these tax brackets work. You're not taxed 37% on all the income you have necessarily if you're in that highest tax bracket. It's a complicated calculation, but let's just cut to the chase. Suffice it to say that if your business has an income of $1 million per year, you're structured as a sole proprietorship, okay? If you file as a single taxpayer, you'll have to pay $357,000 in taxes. If you are married filing jointly, that number's cut down to $318,000. So significant savings, but still over $300,000. If you have an LLC taxed as an S corp or a partnership, the result is the same. You pay yourself a reasonable salary of $75,000, which you pay the $75,000 tax rate on, which is very low. You take the standard deduction instead of the itemized deduction, your tax burden will be $334,000 if you're single. It's a significant improvement over $357,000. If you're married filing jointly, Now you're less than 300 grand. It's 296,000. So if you have a corporation or an LLC subject to double taxation as a C corp, your tax burden goes down to 268,000 if you're single, and 265,000 if you're married filing jointly. So let's get all that together. C corp taxation, the double taxation, can save you almost $89,000 if you're single over a sole proprietorship. And it can save you over 50, I think it's like, 55,000 if you're married filing jointly. So that's because with a C corp, your $75,000 salary is taxed at the 22% personal tax rate. And then, of course, corporate income and profits are taxed at 21%. So you have an average marginal tax rate of about 21.2%. That's the total tax rate you're paying on everything, averaged out. If you're with a sole proprietorship and everything is coming to you, your marginal tax rate, all things put together, is roughly 35%. So double taxation isn't always a bad thing. So like I say, that sounds like a lot of math, and there's a lot more that went into that than what you just heard for sure. But depending on your business circumstances, the structure of your business and how you operate that can save or cost you a lot of money. And when you're thinking in generational terms, I mean, the $88,000, or if you're married filing jointly, but let's just take the lower number, $55,000. $55,000 year over year comes to a lot that you can then leave to your children and your children's children, if we're thinking in generational terms. So this is one of those things where, like I say, part of being wise with your resources is knowing how to do things like this. So if anybody has any questions about business organizations, you can call me anytime. Half of you probably know where I live. So you're welcome to talk to me after service or even after this time tonight. But we're done with business organizations for now, and I am surprised that nobody fell asleep. Good job. So we're gonna go on to contracts next. Really great change of pace, I know. But so why should we even think about contracts, right? What relevance do they have? If you've ever been engaged in a business transaction in your life, you've probably been in a contract. Contracts are not just pieces of paper where both parties agree to do their respective things and then sign on the dotted line. They are that. But contracts can be verbal. The legal definition of a contract is a promise that is made as part of a mutual exchange that the court will enforce. Doesn't have to be written, doesn't have to have any particular form, doesn't have to have a signature. Certain types of contracts do have to have signatures, but not all of them. Many contracts are verbal. A handshake agreement can be an effective contract. So the biggest reason we need to think about this is the simple fact that 80% of civil lawsuits filed every year in the United States involve breaches of contracts, claims for breach of contract. Just in state courts alone, that's 53 million cases a year. 53 million cases a year are brought over breach of contract. And often, it's the interpretation of the contract that's at issue. The parties have a disagreement over what it was exactly they agreed to. They used the same words, but they didn't mean the same thing by it. So in fact, they actually said two different things while sounding like they said the same thing. I have a rather hilarious illustration of this from a case I'm sure you'll recognize. Fregalement Importing versus BNS International Sales Corp. The case opens with the sentence, "The issue is, what is chicken?" Plaintiff says chicken means a young chicken suitable for broiling and frying. Defendant says chicken means any bird of that genus. That means contract specifications on weight and quality, including what it terms stewing chicken, and the plaintiff pejoratively terms fowl. Dictionaries give both meanings, as well as some others not relevant here. To support its claim, plaintiff sends a number of volleys over the net. Defendant essays to return them and adds a few serves of its own. Assuming that both parties were acting in good faith, The case nicely illustrates Holmes's remark, Justice Oliver Wendell Holmes, that the making of a contract depends not on the agreement of two minds in one intention, but on the agreement of two sets of external signs, not on the parties having meant the same thing, but on their having said the same thing. The problem, as we all know, is that what you say and what you mean are not always the same thing. So this is where attorneys can help. Although, to be honest, only an attorney could mangle the meaning of chicken that bad. Yeah, we might not be great with numbers, but with words. So anyway, there's a lot of different cases like this, and attorneys read a lot of them. So one thing that we're kind of trained to do is spot ambiguity and try to bring clarity to the situation. So if you have a written contract, especially if it's a big long contract for a big business transaction, most companies just have attorneys on staff to review them. Just because if you have any feeling that something might not quite be right or that you don't understand something, it's always good to seek help. If you don't want to get your contracts reviewed by an attorney, just don't be afraid to ask questions. Ask the person who you're agreeing with, what do you mean by that? Don't just assume they know what you mean. Say, what do you mean by that? Before you sign. Yeah, good point, Ben. Yeah. Never, ever ask the meaning of a contract after you sign. Do that beforehand. Well, you can ask the meaning after you sign too, but it's kind of stupid. Anyway, if you're involved in business at all, the chances are you're going to come in contact with contracts on a regular basis. So if you're looking to begin a new business, contracts are about to become a big part of your life. So it's a good idea to be thinking about these laws. Start reading up on them, start thinking about them, and if you have any questions, contact a business attorney and ask. There is such a thing as a dumb question, but they don't come around very often. So, all right, if anybody has any questions about contracts, you're welcome to find me whenever you need to. If Brandon has my number, I'm sure several of you all do as well. So if you want it, come to me and I'll give it to you, or go to somebody else who has it. You can give it out. From there, we're just going to go right on into educational law. As Brandon mentioned, I was an attorney for HSLDA. It was my last position before I moved back down. It's probably not something I need to go into great detail about here because, y'all are pretty familiar with the homeschool requirements here in Alabama. This is a homeschooling church, isn't it, Brandon? But for those who'd like a refresher, I'll just do a quick rundown of the requirements, and I can answer more specific questions on a case-by-case basis. Excuse me. Alabama law fundamentally provides a great deal of freedom for parents to educate their children as they see fit. We have a fundamental parental rights statute that doesn't necessarily explicitly cover education, but the U.S. Supreme Court has held that education is a fundamental parental right. Alabama provides a lot of freedom for church schools, private schools, and families to educate their children as they see fit. Alabama statute has specifically disclaimed any authority to regulate church schools, noting that an attempt by the government to regulate a church school would violate the First Amendment to the U.S. Constitution. So not only do church schools have immense freedom here, that freedom is constitutionally protected. The same statute acknowledges that Alabama has no compelling interest in regulating private schools and therefore does not regulate private schools. So church schools and private schools are both exempt from any state certification, licensure, or regulation. And I should clarify, when I say private school, I don't mean an institutional private school only. If you're a family that wants to homeschool independently, you can do that by setting up a private school in your home. And I'll cover the requirements right here. Church schools, the requirement is that you report to the local public school superintendent the first year you enroll your child. After that, as long as you continue to enroll your child in that church school year after year, you don't need to have any further contact with any agency of the state. So it's a very, very good option if you don't want the state having a lot of say in your educational program. because the church school isn't regulated, and the government doesn't even have to know your child's there for most of the education. For private schools, the statute requires an annual report. So if you're not signing your children up in a church school, you have to file an annual report that includes a notice of intent, an enrollment record, and last year's attendance report. Now, here's where a little bit of ambiguity comes in, and you might see this online, people arguing about this. People fight about the Alabama homeschool laws all the time because the state superintendent of public education has purported to waive these statutory requirements. They don't enforce the reporting requirements in Alabama. So if you never report anything, to be completely honest, you probably won't get in trouble for it. But that just relies on the superintendent's mind. The statute does require these reports to be filed, whether it's for the one-time reporting for the church school or the annual reporting for the home-based private school. If the superintendent ever changes his mind, you'll have to make reports or they'll enforce the law on you. And as an attorney, I mean, I'll tell you right out, it's always best to follow what the statute says, regardless of what any government official tells you can get away with. So my recommendation would be to follow what the statute says, file your reports. It's a very de minimis requirement. Just do it. If you want to, this is one thing I've been interested in talking to you about, Brandon, the potential of opening up a local church school in this area for some of the families right here in the immediate area. There's a lot of really great ones. Ezekiel Academy in Montgomery is a really good one. There's a number of others in the area. But some of them tend to be, expensive or longer distances. And some families just don't feel the need to enroll their children in the bigger schools with more offerings. They got a lot of offerings they offer at Ezekiel Academy, but having something local would potentially be nice. If that's not something anyone's interested in, it's not an issue. But what I'm saying is there's a lot of potential across the state of Alabama to have people enrolled in these church schools getting a Christian education where parents have a means of accountability. Because part of the problem with home-based private schooling is that I'm not trying to disparage anybody or say that parents will drop the ball on their children's education. But one of the concerns that we hear from state actors a lot is that where there's no accountability, there's a concern that children might be falling through the cracks. And if we want to continue to have the homeschool freedoms we have in this state, we need to, even if it's not legally required, we need to be willing to provide and encourage accountability for homeschooling parents. That's all I'm going to say on that. If you'd like help making your required reports, talk to me. I can help you. If you're already a member of HSLDA, talk to them. You've already paid for it. The next topic I want to discuss is a topic that I think a little bit hard, might be kind of scary, but I think it needs to be addressed. And that is CPS relations, preventing and resolving CPS investigations. Statistically, one child out of every 3 will have to deal with a CPS investigation at some point in their life. Child Protective Services here in Alabama, it's the Department of Human Resources, or DHR. 1 out of 3 children will have an investigation of their home life and family within their childhood. So this is a huge issue. And dovetailing with what I was just talking about, homeschooling families are at particular risk for this because, like it or not, a lot of DHR calls are sent in by family, friends, or neighbors who don't consider home-based education to be a valid education. For some reason, there's still a lot of people that think homeschooling is per se educational neglect. And of course, some people are just always suspicious of people who don't live like they do. So as a attorney for HSLDA, I dealt with several calls a week from people in Alabama and a couple of other states, with DHR at the door investigating them for educational or physical neglect usually. So it's something I've dealt with quite a lot. About 60% of DHR calls tend to be found unindicated or not indicated. That is, there's no basis for the allegations. That means 40% of them, there's some abuse being found or neglect. So The problem is DHR has a breathtaking amount of power, both in how they conduct the investigation and in what they investigate and how they define it. So, who do you think decides what constitutes abuse and neglect? It's DHR. And who do you suppose decides when those definitions have been met? Right again, it's DHR. And DHR is about the only law enforcement agency that I know of that has the power to take executive action first and ask questions later. They can take your kids out of your home and then later on ask why they did it. If they feel that it's necessary, they can just pull them and then investigate. So you're not dealing with a small issue here. Now, I will say the DHR agents I've dealt with in the past have often been professional, courteous people whose main interest was genuinely in protecting children. But obviously, it's best not to take a risk when you're dealing with an agency with this level of power. I can't remember who said it. It was a military genius once said, um, base your plans on your enemy's capabilities, not on your estimation of his intentions. So here's a few tips for Christian families to minimize your chances of getting a call or visit from DHR and to deal with one if one comes up. So first, going to the prevention side. First, be very, very careful what you say to whom. Like it or not, biblical positions on matters of education, child training, discipline, and family life are becoming less and less popular. Fewer and fewer people understand or agree with these positions. And especially as popular notions of what constitutes abuse are becoming more and more unhinged as the psychotherapy industry continues to give the world more and more reasons to blame all its problems on somebody else. So, unless you trust someone 1000%, don't tell them how you train or discipline your kids. Don't tell them details about what your living arrangements are like at home. Don't tell them how your children are educated or what you use to educate them. Don't loose your lips and risk your ships. Just be careful. Be very, very careful. The second one may seem obvious, but cleanliness is next to godliness. Okay. I don't have to say much about this here at this church. Y'all's kids come in here looking bright and beautiful every Sunday. It's glorious to see. But, just something to keep in mind, keeping your home reasonably tidy and uncluttered, keeping your kids clean, well clothed. People do make judgments based on that kind of thing, right? Child walking around with a dirty face, uncombed hair, maybe dirty clothes. It looks more like neglect, right? And somebody who might be more willing to call DHR is generally more fastidious in those areas as well. So keeping things clean can be a good preventative. Third one, and this is something that obviously Pastor Brandon has spoken about before, um, especially to those of us with younger children. You got to be reasonable in your discipline. To just keep it reasonable. The Bible does say that one who spares the rod hates his child. We are commanded to use corporal punishment on our children in certain circumstances. And that is a very unpopular position today. A lot of people would say that corporal punishment is per se abusive. But you got to be wise in obedience to God's commands, right? We got to understand that what we're dealing with. And to be honest, excessive spanking was never God's plan anyway. You got to do it right. If you're angry, don't risk your kids on a moment motivated by wrath. Cool down and then administer discipline lovingly and in proportion to their mistake. You just need to be wise as serpents in dealing with this. So, like I say, train your children according to biblical commands. Don't be excessive, because if you are excessive, that's exactly the kind of scenario that DHR is looking for. And that's the same kind of scenario that will get your children likely taken from your home. You don't want to obey God to such an extent that you lose the very reason you were obeying him in the first place. Number 4, and this goes back to homeschooling as well, actually educate your kids, right? I don't have anything to say about this place. We take education very seriously here. I know that from experience. But, I saw this at HSLDA sometimes where homeschooling families didn't have any records, their children didn't pass tests. It is a real problem some places in the homeschool community. So, just make sure your children are being educated. It might be a lot to take care of. It definitely is. We're homeschooling a bunch right now. It's hard to do, but you got to keep up on it. And then, of course, dovetailing off of that, keep good educational records. Many of the DHR calls I've fielded were involving educational neglect. And in most of them, DHR was asking for documentation like what they would expect from a public school. I don't think that's malice so much as ignorance on their part, ignorance of what the law requires of homeschoolers in Alabama. But Alabama doesn't regulate church or private schools. You don't have to keep records. You don't have to show any records to any agent of the state ever, other than your annual reporting, like I said. But you don't have to give evidence of your curriculum. You are under no licensing, testing, curriculum requirements, anything. But that said, DHR has the authority, right, to take the kids first and ask questions later. So it's always a good idea to go above and beyond and have good records and be able to show them, yeah, these kids are smart. They're getting educated, right? It's just a good idea to show the DHR that you're acting in good faith, which helps them to feel better towards you as a person, and then also alleviates fears that your children are being neglected, because let's face it, nobody wants children to be neglected. Okay, so now going from the prevention side to the mitigation side. If you do get a DHR call or visit, first thing to remember is don't panic, call for help. If you're a member of some great organizations like HSLDA or Heritage Defense, call them immediately. This is what you pay them for. You tell them you have a DHR case. Little pro tip for HSLDA members, if there are any in the room. HSLDA deals primarily with DHR calls involving educational neglect. They're a little less helpful when it comes to non-educational neglect cases. I tended to stretch the boundaries on that when I could, but most of the attorneys don't. So there's Heritage Defense has a much broader area of coverage in that respect. But if you are not a member of either Heritage Defense or HSLDA, you're welcome to call me. I've done this before. I'm willing to help. So if anybody needs it, that's an option. Number two, remember that you do have rights in this situation. You have every right against DHR investigators that you have against any other law enforcement official. You have the right to refuse them entry to your home unless they have a warrant. I wouldn't recommend doing that, because if they do get a warrant, then you're not in control of the process anymore. So that's another story. But the biggest thing is you don't have to say anything that might incriminate you. You don't have to give them information just because they ask for it. You have the right to remain silent in a DHR investigation. You're going to be nervous, your heart's going to be pumping, and you're going to want to spill your guts, but you do not have to, and it's usually best if you don't. Number three, and this is one that you really, really need to remember, always ask what the allegations are. DHR doesn't do general scope investigations. They investigate specific allegations of abuse or neglect. You need to ask what the allegations are, because if you don't, you have no way to know what they're investigating, and that way you can't cabin their investigation into matters relevant to the allegations. So it can very easily turn into a fishing expedition. My favorite story on that front is one where I had to ask a DHR investigator just how she expected to look in my client's fridge to help her with her investigation of educational neglect. She dropped the fridge and got back to education pretty quickly. So if we didn't know what the allegations were, we couldn't have asked that question, right? And say my client hadn't been to the grocery in a week and was running low on groceries, the DHR investigator's mood might have led to a bad outcome for her. If you have advance notice of the DHR visit, take measures to make your home exceptionally pleasant. This goes into a little bit of psychology. You clean the place up to your highest standards, clean everybody up, get everybody dressed in their good clothes, right? Not necessarily Sunday best, but good clothes. Maybe light a few candles, bake some cookies, get those aromas flowing. The goal is, you got to remember, DHR agents, they very often see the worst of humanity, okay? They're out in the trailer parks, seeing these kids starving to death while dad is who knows where and mom's strung out on drugs in the living room, right? And they're coming to your place not knowing what to expect. They don't know if they're going to see a thriving, happy family or kids being chained down in the basement and whipped every day. You know, you got to be careful to make a nice, welcoming environment for them, because that's a really great way to lower the temperature in the room without even having to say anything. So the minute they step across your threshold, they're like, oh, okay, well, this is better than I thought, right? Because they come in expecting the worst most of the time. And this next item goes into that. Be friendly and have your kids be friendly. And above all, make sure the investigator sees your kids within the first 5 minutes of the visit, because being able to set eyes on the kids also lowers the temperature, because like, okay, yeah, nobody's chained up in the basement, right? All the kids are here. They're clean. They're well dressed. They're looking good. Whew. We can relax a little more. Okay. And then the investigation becomes, okay, what do I need to hang my hat on so I can write these people a not indicated letter and let them get on with their lives? Rather than, okay, what do I write up first? Right. So the last thing is, and this goes to knowing your rights as well, be wise in your answers, right? When you get asked questions by DHR agents, just answer the questions that are put to you simply, succinctly, and don't volunteer extra information as a rule. Pretend it's a courtroom, right? Everything you say can be held against you. Just answer the question directly and do not dance around it. If you think the answer might look bad for you or incriminate you, just tell them you don't wish to answer. You don't have to answer it. You are not bound to incriminate yourself. So just be wise, use good judgment. And of course, if you have an attorney on the phone, which I highly recommend you do, it's always a good idea to have them, if possible, be on the phone or present when you're being questioned, so they can tell you whether to answer or not. I used to do that at HSLDA fairly frequently. So every DHR visit is going to be different. They're not going to look the same, but they're all going to be harrowing and stressful. So being prepared for this mentally is important. Now, everybody knows the best laid plans of mice and men, gang after glay, I think it was, Bobby Burns, whatever that was. But you need to have your mind understanding these concepts. You need to be thinking about this possibility. Chances are 1 out of 3 children in this church will have an investigation on them. And knowing the sizes of families in this church, that means more than 1 out of 3 of the kids in this church. So we need to be thinking about this. I hope what I've said tonight can help you in learning all this stuff. So we don't have a whole lot of time left. I'm going to go really quickly through the last issue. And of course, I'm hoping we can discuss this at greater length at some other period. And of course, as always, I'm available for questions tonight or any other time you can catch me. Alternative dispute resolution. I want to read a passage from 1 Corinthians 6, and this goes to disputes that are between Christians. I want to call attention to this because a lot of the lawsuits that we see filed every year are between people who claim the name of Christ, and that is a tragedy. Paul writes, "Dare any of you, having a matter against another, go to law before the unjust and not before the saints? Do you not know that the saints shall judge the world? And if the world shall be judged by you, are ye unworthy to judge the smallest matters? Know ye not that we shall judge angels? How much more things that pertain to this life? If then ye have judgments of things pertaining to this life, set them to judge who are least esteemed in the church. I speak to your shame. Is it so that there is not a wise man among you? No, not one that shall be able to judge between his brethren. But brother goeth to law with brother, and that before unbelievers. Now therefore there is utterly a fault among you, because you go to law with one another. Why do you not rather take wrong? Why not suffer yourselves to be defrauded?" What do you think Paul's opinion of Christians suing each other really was? Christians in general need to seek to resolve disputes outside of court. That's the long and the short of it. And thankfully, our legal system recognizes and to a greater extent encourages avenues of alternative dispute resolution, such as negotiation, mediation, arbitration. Those are three major categories of alternative dispute resolution methods. And what we can do as believers, and we could work this into business agreements, we can work this into the very foundations of our, I insert alternative dispute resolution clauses into LLC operating agreements all the time. You can put these kinds of principles in the operating agreement to oblige people you do business with to pursue these kinds of systems with you. But a typical ADR plan, alternative dispute resolution, ADR, involves all three levels: negotiation, mediation, arbitration. And this, interestingly, happens to take the form of the typical Matthew 18 plan for dispute resolution. Let's review Matthew 18 here. Moreover, if thy brother shall trespass against thee, go and tell him his fault between him and thee alone. If he shall hear thee, thou hast gained thy brother. But if he will not hear thee, then take with thee one or two more, that in the mouth of 2 or 3 witnesses every word may be established. And if he shall neglect to hear them, tell it to the church. And if he will neglect to hear the church, let him be unto thee as an heathen man and a publican. So what we see in this passage is a strategy of using the lowest formality possible to resolve the dispute, climbing the ladder as necessary. Beginning in simple discussions between brethren, negotiation, right? Moving to the assistance of one or two more, which is mediation, where a third party, a neutral third party, goes between the parties and tries to mediate an agreed upon solution. And then it ends in the binding arbitration of the church. So that's precisely the typical flow of the typical ADR plan, such as the one that I typically insert into my LLC operating agreements. So if anybody wants to see an example of a Christian ADR plan, I've got a great template that I can show you. So if you'd like to give me a call, I can email you a copy of it, just a template plan that you can look at. And if you have questions, we can discuss things. But, obviously, I don't have time to go through all this. And I have a lot more that I was going to go through that I don't have time to. But the churches are well placed and well situated to help with these kinds of issues. Pastors and church leadership make great mediators and arbitrators even. Christian attorneys like myself, like Ben, like Colonel Eismo, who was here earlier, we can serve as arbitrators. We can serve as advisors to arbitrators, or we can serve as mediators. Our services, we're trained in this kind of stuff. Our services can be used to facilitate dispute resolutions outside of court within the church. And I think we should be making that our goal. I think we're uniquely suited to this role by God because we have the gift of the Holy Spirit. We have the gift of God's Word. We have the ability to interpret God's Word in accordance with the mind of Christ. And if that's not sufficient to resolve our own disputes, why on earth do we think the secular law written by unbelievers is any better? We're going to judge angels. Let's judge between ourselves. Let's set the example to the world for resolving disputes in peace and brotherly affection, in submission to the authorities of the Word of God and His holy church, and doing all things to God's glory and our neighbor's good. So I thank you all once again for the ability to speak to you tonight. Thanks for the opportunity. It's a lot of fun to prepare for this. I actually learned a few things that I'd forgotten, so it was a good refresher course. I really look forward to speaking with you all again next week, and I hope you have a good week until we see you again.